Clients often come to me because they're facing removal proceedings in the immigration court, or because perhaps they already have a final order of removal based upon a criminal conviction, often for what's called an aggravated felony. And I will ask them, did your lawyer warn you of the immigration consequences of the plea deal that you made? And commonly the answer will be, well, I remember that the judge did. And I'm like, no, I asked about the lawyer because the lawyer and the judge have a very different standard, a very different duty. And now the Supreme Judicial Court has made that extremely clear. And so we have this great new decision that I'm looking forward to talking about in this video. Hello, I'm Attorney Lewis Haskell. And as I say, I'd like to talk about the case of Commonwealth versus Santana, which the Massachusetts Supreme Judicial Court just handed down on February 4, 2026. And this is an interesting case. Mr. Santana, unfortunately, was convicted of possession of intent to distribute of heroin, which is a drug trafficking offense, which makes it an aggravated felony. And at the plea colloquy, where he was talking to the judge about the plea, the judge specifically asked, did you discuss the immigration consequences of this plea with your attorney? And Mr. Santana answered yes. And then when they brought the Padilla motion indicating, and Padilla, by the way, is a 2010 US Supreme Court decision, which imposes upon attorneys a duty to warn clients about the immigration consequence of their plea. And we really have much clearer duties on attorneys in terms of warning their clients. And this Santana case makes that abundantly clear. Because again, the judge asked, did you discuss it with your attorney? There is, and also the judge will make a statement as part of the plea colloquy that this plea may have immigration consequences. And there's a paper that every criminal defendant in Massachusetts signs when they enter into a plea agreement in which they acknowledge that they have been warned that this plea may have immigration consequences. But to say that an aggravated felony may have immigration consequences is inadequate. It's wrong because an aggravated felony is virtually certain to have an immigration consequence. There really aren't a lot of defenses to an aggravated felony. When you look at, for example, the original Padilla case, Mr. Padilla came to the United States as a child. He lived here for a very long time. He was married. He had children. In fact, his wife was disabled, so he was the sole source of support for his children and for his wife, all of whom, by the way, were U.S. citizens. Obviously, he was working. He was actually, other than the fact that he was dealing drugs, a fairly upstanding character. And none of that matters with an aggravated felony. The defenses are sometimes when you're helping law enforcement to nail somebody bigger than you, the Convention Against Torture, which right now isn't even so great because they'll just send you to El Salvador, it looks like. But at least they won't send you to your home country. And sometimes under the right circumstances, like for example, if you're a refugee or you entered the United States as a refugee and never left the country, and then you marry a US citizen, maybe you can get around the aggravated felony bar. For the most part, there aren't defenses to aggravated felonies in ways that there are for every other kind of crime. And thus, the Supreme Judicial Court has now made clear and unambiguous. The lawyer must tell the client in such circumstances that their deportation is a virtual certainty, or at least the deportation order is a virtual certainty. And frankly, that's kind of important now because what we're seeing is, for example, let's take some countries I'm very familiar with here in Lowell, Cambodia, Vietnam, countries where historically it's been difficult to impossible to deport to. And all of a sudden we're deporting there. There are a lot of countries that we haven't been deported, Venezuela, that we haven't been deporting to, that suddenly we are able to deport to. So this idea that you get a final order of removal, but so what? You're not going to get deported has kind of lost all meaning. So it really is a virtual certainty. It's something bad is going to happen on the immigration side. And so when the lawyer filed his affidavit, look, kudos to him. Most lawyers will do this, by the way. They'll admit that they did not give a good instruction. Every so often, in my cases, I'll run into one who is worried about the consequences of admitting that they messed up. And it's so annoying because, first of all, it's just unprofessional. But second of all, for the most part, there really aren't any. I actually, as fate would have it, I had a case down in Essex County, down in Lynn, where the district attorney was actually threatening to file a bar complaint against the defense lawyer if she acknowledged that she failed to give the right warning. In fact, in this case, and she didn't give a warning, and she would eventually acknowledge that she didn't. In fact, what she said to me was, who knew that a state court misdemeanor in which a client did not serve a single day in jail would be a federal felony? It's all about legal ethics and whatnot, but how to be an effective lawyer, how to do your job, run your business, all that good stuff, and do it within the rules. And it's usually taught by bar counsel. In those years, it was definitely taught by bar counsel, Constance Vecchione. Actually, she was assistant bar counsel at the time. And I spoke to her about it. You know, what would you do if a prosecutor filed a complaint against a defense attorney saying the defense attorney's representation of a criminal defendant was inadequate because they didn't give a proper immigration warning? And she looked at me like I had two heads. I mean, her first response is, are you kidding me? She was able to spin a scenario in which she would take it seriously, but that would be in the case of a lawyer who just had a long track record of disciplinary problems. And so here, though, we have a lawyer who did his job, or didn't do his job, really gave the wrong warning, admitted it. He wrote an affidavit saying, I told him that he may be deportable and that this may block his path to citizenship. And the judge, interestingly enough, refused to hold a hearing. He denied the motion, saying, listen, I asked, did you discuss the immigration consequences? He said yes. And the Supreme Judicial Court said it's one thing to say you discussed the immigration consequences. It's another thing to say that the lawyer gave the correct warning, and this lawyer did not. So I now have a new arrow in my quill. All lawyers who do what I do now have a new arrow in their quill when presenting these like motions in the Massachusetts State Court to indicate that, frankly, a lot of warnings that lawyers have given have been hedged, and those hedges are unacceptable. They're inadequate, and they amount to ineffective representation of counsel, and thus are a constitutional violation, which can enable not only the criminal conviction to be vacated, but the deportation case itself to be reopened, even if a final order of removal is in place. And under the right circumstances, even if the person's already been deported, potentially have them brought back. So if you find yourself in this situation, good time to come in and talk about it. Certainly there's a lot going on with ICE, so anything that can happen or keep ICE away from you or to get ICE away from you is well worth doing. Thank you.